that you are a child living during a strict period of time where anything you could do could get you into trouble. Imagine if you were in trouble with the law and had no rights whatsoever to defend yourself. It is as simple as you did the crime, you do the time, no matter what the circumstances are. If you can picture this, then you can imagine what it would have been like to be a child living during the 1900s. If someone said they saw you doing something that you weren't supposed to do, then you were punishable by law, be it true or not. Now imagine that you lived during the 20th century, where as a child you had every right to defend yourself. Which time period would you rather live in? To understand the juvenile justice system, one must first understand its history, its structure, and the rights given to the juvenile, both past and present. The beginning of the juvenile justice system occurred when changes in the cultural conception of children and in strategies over social control led to the development of the first juvenile justice court in Cook County, Illinois, 1899, during the 19th century. According to Barry C. Fields' Juvenile Justice, History and Philosophy, prior to the creation of the juvenile courts, the common law's infancy defense provided the only special protections against juveniles who were charged with committing crimes. Common law states that children 7 and younger lack criminal capacity, while children 14 and older possess full criminal responsibility. During this time, some states would execute children as young as 12 if they were found to be criminally responsible. The first age-segregated institution, known as the House of Refuge, appeared in some East Coast cities in the early 19th century. By mid-century, reformatories and youth institutions began to spread to rural Midwestern regions. The refuge legislation consists of 3 legal innovations. It consists of a formal use of distinction between juvenile and adult, the use of indeterminate commitments, and a parens patriae, which, according to the Gale Encyclopedia of American Law, is a broad and legal authority. It is the right and responsibility of the state to substitute its own control over juveniles and their natural parents when they seem to be unable or unwilling to fulfill their responsibilities, or when the child becomes problematic to the community. Now that we have talked about the history of the juvenile justice system, let's get a brief understanding of its structure. The juvenile justice system became redesigned largely in the image of criminal courts. According to Bernard J. Thomas, who wrote The Cycle of Juvenile Justice, every jurisdiction continued to hold some form of juvenile court. Even though lawmakers invented a number of different structures to incorporate the idea of juvenile court into already existing policies and procedures. The new policies and procedures varied from state to state, and many communities did not actually have a completely separate court just for juveniles. The courts responsible for handling cases of young offenders were either part of the Superior Court or Circuit Court. Understanding the structure of the juvenile justice system is important, but understanding the rights given by law to the juvenile, both past and present, is also equally as important. Prior to the 1960s, juveniles had no due process rights. It was thought of as unnecessary considering the purpose of the juvenile court was to help them rather than to punish them. Jeffrey A. Butts in Juvenile Justice, Juvenile Court states that juveniles had no right to an attorney unless they lived in a jurisdiction where it was then granted by state or local law. They had no federal right to inspect or challenge evidence brought against them, and no right to a formal notice of charges. In 1967, Supreme Court ruled in the case of Henry Galt. Henry Galt was the case of a 15-year-old Arizona boy named Gerald Galt. He was charged with making an obscene phone call to a neighbor. He was then picked up by local authority and placed in juvenile detention. They did not notify his parents that he was in custody, and they did not hear testimony from the victim, nor did they even establish if Jill was the one to actually make the phone call. The Supreme Court ruled that juvenile proceedings where confinement was possible, that juveniles had a right to a formal notice of charges, the right to cross-examine, and the right to assistance of counsel, and the right to protect themselves against self-incrimination. By the 1980s, juvenile courts were constitutionally domesticated. The courts followed a higher standard of evidence, and education was equivalent to that of criminal conviction. However, juveniles were still denied the federal rights to bail, speedy trial, and the right to trial by jury. Justice Potter Stewart said in his disagreement to the decision of Henry Galt that the introduction of greater due process for juveniles may have had the unintended consequences of encouraging states to make their juvenile courts into criminal courts. The inflexible restrictions that the Constitution so wisely made applicable to adversary criminal trials have no inevitable place in the proceedings of those public social agencies known as juvenile or family courts, and to impose the court's long catalog of requirements upon the juvenile proceedings in every area of the country, it is to invite a long step backwards into the 19th century. 30 years following the case of Henry Galt, legislators across the U.S. continued to enforce due process reformations that were endorsed by the Supreme Court. States gave judges the right to blended laws. This mixed criminal court sentences with juvenile courts dispositions. Judges were allowed to send juveniles straight to either juvenile or adult corrections. Sequential confinements were then endorsed so that once a juvenile reached the age of adulthood, they would then transfer to adult corrections to finish out the remainder of their sentencing. I hope that you are now able to understand the history, the structure, and the rights of the juvenile justice system. The juvenile justice system is very complex. The rules and procedures of every jurisdiction vary from state to state, making sure that no one jurisdiction is the same as any other. It has come a long way from a time when there was literally no rights given to a juvenile, whether you were either an offender or, in Gerald Galt's case, suspected of being an offender. While listening to this speech, I hope that if you are a juvenile, you learn to appreciate the rights that you have. And if you are an adult, I hope that you feel armed with knowledge of a very important part of our judicial system.